Hello, and thanks for joining us. I'm Josh Gingold, and this is Ensuring HIPAA Compliance with a Business Associate Agreement, or BAA, brought to you by Ziff Davis and eFax Corporate, the world's #1 online fax brand. Our presenters today are technology analyst Chris Dawson. Chris, good morning. Thanks for joining us.
Thanks for having me.
Pleasure always, and we're also happy today to welcome a new speaker to the Ziff Davis family, HIPAA compliance trainer Ross Leo from HIPAAtraining.net. Ross, great to have you on. Appreciate it, of course, without a doubt, and looking forward to everything you have to say today.
Very glad to be here, Josh. Thanks for having me.
Absolutely. And before we begin, I do want to let everybody know that the information provided in this presentation does not constitute and is not substitute for legal or other professional advice. We strongly encourage you to consult your legal or other professional advisors for individualized guidance regarding the application of the law to your particular situation and in connection with any compliance-related concerns. Gentlemen, it goes without saying, but these HIPAA regulations are no small deal whatsoever. And of course, with the omnibus final rule that went into effect in September of 2013, the stakes are high. Ross, are you seeing an uptick in activity at HIPAAtraining.net as businesses grow increasingly concerned over what many would argue is kind of a complex addition to the HIPAA and high-tech regulations?
Yes, I have. I've seen a tremendous amount of interest in what does it mean, what do I do, help, all of that kind of thing. But yeah, there is a great deal of interest and concern to make sure that they have the right understanding and that they take the right steps without false starts.
And omnibus and high tech are really big deals. Some would call it these omnibus final rules that took effect in September 2003. Some would call it the biggest change to HIPAA in 15 years. And of course, what we're talking about is the omnibus rule of the High-Tech Act that many healthcare providers are trying to come to terms with in terms of the requirements for documenting business arrangements with vendors. That's the big provision. That's what's really changed, and we'll go into that in just a moment. The term business associate, of course, refers to really any entity that provides supporting products and services that are private health information related, PHI related. This is a very, very big deal, and there are many, many provisions to it, and we've gone over those on past webinars, and I encourage you to look into it. There's a 500-page plus document that is just related to this omnibus final rule, and if you're on this webinar, then my guess is you're well aware of it. But this idea of protecting your business against the actions of business associates who may be handling PHI data is very, very important. Of course, we also know that the term business associate, as I said, refers to any entity that provides supporting products or services that are related to protected health information. Now, there are some exceptions to that, and we'll go into those in just a moment. But Chris, this is a really broad segment. If you're looking at a hospital and all of the different vendors that may be touching this data, whether it's on the IT side or call centers, whatever the case may be, if you look at the term business associate, it covers a lot of ground.
Well, it really does. I think this is what has people a bit nervous, whether you're a healthcare provider and want to make sure that all of your dealings are on the up and up with whomever you're working with, or you are providing services in the healthcare vertical. Am I a business associate? How do I know if I'm a business associate? How do I know if I need to have one of these agreements in place? And if I do have one of these agreements in place, just what are my responsibilities and liabilities? The people are nervous for good reason. I think there's a bit of, well, not just a bit, a fair amount of uncertainty floating around about what really constitutes a business associate, and that's a question that absolutely must be answered, whether by lawyers or consultants or whomever.
And, of course, that's where our special guest today, Ross Leo, comes in with HIPAAtraining.net. Now, Ross, we know that the way that you provide this protection that Chris is talking about is through these formalized business associate agreements. And, of course, that's familiar ground for you. You're advising clients on exactly how to shape these things, but they are legally binding and they need to be taken seriously.
Oh, that's absolutely true. They're like any contract. There's There's going to be a lot of terms and conditions. And when you construct it, it needs, of course, on the one hand, to be in compliance with what the law is specifying, but it's also got to be a sound contract as well. So there are an awful lot of points that you have to be comfortable with and familiar with. And it's not something that you just say, okay, I've got one. Here it is. We're done. You need to read it. You need to be intimately familiar with what it says, because as we've seen in the news, a lot of people are getting hit with a lot of fines, a lot of investigations, privacy breaches, the whole gamut. So you've really got to pay very close attention to this.
And, of course, everything that's healthcare related right now is getting an awful lot of attention, some would say scrutiny, because of the new National Affordable Care Act. So healthcare is very interesting, and there will be a lot more rules because ostensibly there will be a lot more people in the system. But we've covered this ground. I want to provide a quick example that was given to me recently, and I think it's a good one. And I just want to walk through this for those of you who really want to understand what this means and who it does and does not apply to. So let's take the example of a hospital, which would be a covered entity. That would be the primary health care provider, the hospital, the medical group, whatever the case may be, referred to as the covered entity. What we've been talking about so far are business associates. Okay, but this covered entity for whom the business associates would work, let's say that they adopt an electronic medical record system or EMR system. Chris, I know you're very familiar with this. This is probably one of the single most important trends in healthcare IT right now. Well, if you take that example one step further, that company, that vendor that is providing that EMR software, that is a mouthful, then they're a business associate, and let's say that they need access to PHI or protected health information for support or to keep the system running right. It's not always the case, but let's say that they may at some point need access to that software on either on premises at the hospital or through a cloud provider, whatever the case may be, or rather a hosted provider, then they would need to complete a BAA. And Chris, in a hospital environment, if you think about a campus, that could be a significant number of business associates, if you will, whereas in a smaller, let's say, a doctor's group, it's a little easier to manage. I imagine they have legions of people who are just looking at these relationships now to determine who is and is not a business associate that would need to be covered by a BAA.
Well, that's true. And if you are a very large practice or a big hospital, then you certainly do have more than a few people thinking about this. What's interesting, though, is that lots and lots of smaller practices are being absorbed by hospitals all the time. And so you have these little neighborhood medical clinics, for example, that are now having access to major EMR systems and are having to integrate their own systems and maybe even had their own systems, their own electronic systems that now need to speak with larger systems, and they're adopting their new owner's EMR. There's a lot of things happening in terms of consolidation that are make this kind of front and center, no matter how big a practice and no matter how many patients you deal with on a daily basis.
And keeping with this hospital EMR example, let's take it one step further, and let's say that the hospital is using cloud-based services to store all that data that contains this protected health information. That cloud-based services provider would also need to complete a BAA. But this is where it gets really interesting, and folks, we're really simplifying here. I cannot say enough that we're not trying to give you any kind of legal advice here. Take everything that we're saying at face value, but do your own due diligence to ensure that you're looking at these relationships correctly, because there are exceptions. And the exceptions are, it's really interesting, it's right in the FAQ that's available on the Department of Health and Human Services website, but a BAA is not required for organizations, and this is quoting, such as the U.S. Postal Service, makes sense, even though they're handling those letters, etc., those packets, certain private couriers, and their electronic equivalents, my emphasis. That could be, for instance, a cloud provider that is not hosting PHI data on its servers, but is rather just a conduit. And Ross, this is what is referred to quite often as the conduit exception, which is a topic we're going to take on the next part in this series. But that conduit exception is very important. How do you advise your clients to know when a conduit exception applies, or quite frankly, when they don't need a BAA, because that could be complicated and a costly decision if they're wrong?
The way that we typically look at a situation like this is to take the Department of Health and Human Services definition of a business associate. What are they? What do they do? What sort of things could they reasonably be expected? And that's a very, very important word, reasonably. What could they reasonably be expected to need access to? Then we take the definition of courier or conduit. It is, as you say, someone who simply gets it from point A to point B, like the Postal Service, or the telephone company, like AT&T. Not a service provider, but the telephone company. So we walk through who the entity is and what they actually do and what the reasonable expectation would be for information access. Phone company is like the Postal Service. Little envelopes, little packets of data that are going by, they're just getting them from one place to another. They don't have a reasonable expectation to look in them and see what's there. So by getting that precise, by being that careful to scrutinize the role, we're able to put people in either the BA or the conduit kind of exception. Now, OCR itself has said this is a very narrow kind of an exception. So we have to be very, very careful. Again, the word reasonable becomes very important because, as you correctly point out, an EMR provider, it's very reasonable to expect that they may need to see the data, the actual PHI, in the course of their technical support. But someone like a phone company or UPS or somebody like that, the expectation really isn't there. But we have to be extraordinarily careful how reasonable and how finely we define this thing, because if you get caught making it too broad, then you may be in a position where you needed to have one and didn't. But on the other hand, if you define it too narrow, you may be giving somebody some responsibility by making them do a BAA when maybe they didn't need to. So, like the other issues we've discussed so far, it really requires a really strong understanding of the definitions and how to apply the reasonable rules to make sure that you're looking at it the right way and doing the right steps from there.
Now, Chris, I know that you have, and like me, you've poured through that 500-page document. I'm sure you've read every word of it. But you've spent a lot of time with IT administrators and decision makers who are in healthcare fields. Is it reasonable to think that, and it seems to me kind of obvious, but is it reasonable to think that if you're a smaller doctor's office, of which I know there are a number of those types of people on this call today, but if you're working in a medical group, there's several doctors in there, and you're getting IT support from a third-party consultant or an implementer, if you will, a channel partner of some sort, a VAR, you've got to have maybe, and Ross, feel free to weigh in here as well, but you need to have not only an agreement with that business associate, that consultant who's advising you on your technical capabilities and reasonably is going to be in your software and providing that necessary support, but potentially the subcontractors of that business associate. Is that correct?
Well, I think it all depends on who, again, as Ross pointed out, who could potentially have access to real patient data. But if you think about a system, whatever that system might be, that's managing a whole lot of very diverse patient data, exchanging that data with other systems and making it available to hospitals or other providers elsewhere, yeah, you're right. I mean, the chances of a subcontractor or someone along this sort of stream of information having access to the data, it's quite high. And so now all of a sudden, as a small medical practice, you've got to have a pretty darn fine understanding of just where information is flowing. And this relates to something that a lot of IT folks sort of take for granted, is this idea of documenting and really understanding data flows. But it's not something that comes so naturally to a healthcare provider or even someone who's been working in healthcare IT for a while, because it hasn't been as essential to know where things are moving around. Now they're moving around much more frequently. It's the omnibus rules and new HIPAA rules make it much easier for data to move around, and so the chances of some sort of subgroup or a hidden subcontractor touching data, it becomes much higher.
And Ross, staying on this topic of subcontracts, and as Chris points out, the flow of data that could be PHI related, and there's also hard copy versions of this data too. So this subcontractor portion of it is terribly complicated, but I would guess that you would want to have some note of that in your privacy statement that's going to go to the patients that are in your system to begin with.
Yes, that is absolutely true. One of the things that I find is very common is the covered entities that give out that notice of privacy practice find themselves brought up short many times, because when something does happen and the patient says, well, I didn't know that. How did you do that? Where did you get the permission to do that? The law gives covered entities, individual providers or hospitals, either one, it gives them certain rules that they have to follow. Sometimes they have to get patient authorization or inform the patient. Sometimes they don't. But what the law always requires is that they have to inform the patient that these conditions could apply. Having a patient learn by some unplanned channel or through some unplanned or unsuspected way that their information is flowing in various places to various parties in ways that they didn't know about, that kind of surprise is not a surprise, it's a shock. And they can have a great deal of difficulty with that. So you have to make sure that you inform them that these conditions, and the new omnibus rules are very clear about this. They say that you have to inform even more vigorously than you had to before that these kinds of conditions could exist. Sometimes patients have the ability to opt out, not of these business-associated relationships, but you have to be sure that they know what their rights are and what's going on. It's usually the worst mistake to make, to leave it, oh, well, it's not that important. They'll just assume that we're doing this or whatever the expectation is. But that unspoken interaction that's going on, that they learn about and are surprised or shocked by, that can have some very unfavorable effects on the covered entities and their business relationships with their patients. So you have to be very forthcoming.
Now, as the layman of this... Go ahead, Chris. Sorry about that.
I was going to say, it's interesting. How often do we go into a doctor's office and we sign their HIPAA compliance policy, and we just sign it because we get it and really just want to go see the doctor and get our flu shot or whatever, and we don't pay attention to it? And how often do the doctors really say, no, this is a new privacy policy that we have. Really like to go over some points on it, or the receptionist who sees you and has you sign it. That sort of thing. It's just old hat for most folks now. And yeah, okay, it's your HIPAA policy. Whatever. Here's my signature. But it does become really, under these new rules, far more incumbent upon the provider to ensure that, one, they have an updated policy and that policy is abundantly clear, and two, that patients really understand it and aren't just blindly signing it.
Chris, I couldn't.
That was going to be my question as well. Sorry to interrupt, Ross. That was going to be my question as well. I know I don't read them. So what are the rules? How do healthcare providers protect themselves with these new rules?
Well, if I can jump in, first off, I want to say that I agree completely with Chris's point. Second thing is, in my consulting practice, I find that a lot of the physicians they object to HIPAA first off because they feel like it takes away from face time. Well, what I counsel them to do is to use that as improved patient relationships with their patients. You're talking to them about their health. Why not talk to them about the health of their privacy and how you, as a good steward of that information, are safeguarding it as their advocate, as their protector. You're protecting their health. Why not protect their privacy as well? So the provider organizations can very definitely use this as an opportunity, as Chris was alluding, to show the patient that they're caring for the whole person, their privacy as well as their health, because it really is all about a healthier human being. So this is a great opportunity for them to have more and better quality face time with that patient, and they should take advantage of it.
Okay, every time you guys talk, I have dozens of questions. I'm going to save them to the end so that we can get to what you're going to show us in just a little bit here, Ross. I want to remind everybody, though, that you can submit your questions and comments by using the Q&A button at the bottom of your console. There's 4 little buttons down there. Click on Q&A. You'll get a window. You can enter your question or comment. Good time to enter them all now so that we can sort them out, but we encourage you to do so. We're very lucky to have, of course, Ziff Davis Senior Technology Analyst Chris Dawson and HIPAAtraining.net compliance expert Ross Leo. So get those in. Before we get to Ross, a couple of quick challenges that you need to be aware of, and I'll go through these quickly. As you already know just from listening to this conversation, the new omnibus rule of the HITECH Act, which falls into the HIPAA regulations from the Human Health and Services Department of U.S. government, it's complicated. There are a lot of provisions. There are a lot of exceptions. We talked about the conduit exception. There's also some exceptions for research in terms of allowing researchers to access data that's anonymized and aggregated, etc. So you really need help, to say the least, because everybody's mileage varies and no two situations are ever the same. It's a good idea to get some professional help. Also, as Ross alluded to at the very, very beginning of today's presentation, business associate agreements, BAAs, they go by a bunch of different names, but that is sort of the name that's taking hold. They're legally binding. And the new omnibus rules do provide for a substantial amount of liability if you're found to be in violation. So again, just makes the case for some professional help. And then finally, and this one actually is probably as important as anything that we can tell you today. It's very easy for business associate agreements, these BAAs, to be misused and therefore to diminish their value. And the best example I can give, and gentlemen, I'll ask both of you to comment on this, the best example I can give is, and actually this was shared with me, it's not original thinking, but it really struck a chord, vendors, business associates potentially that are trying to get a contract with a hospital, putting themselves out there and saying, and of course we have a BAA template that we'll sign to differentiate their service, and I think that that's very relevant. It really does diminish the value, Ross, of what a BAA is intended to be. It's not a selling point, and it may not protect the covered entity if it's just templatized and it's not specific to the situation, for example.
Oh, I would agree. The original intent of this thing was to make sure that everybody that has a reasonable expectation of handling this very sensitive information is going to treat it appropriately in accordance with the rules, obviously, but also that there are the accountability and penalties for those who don't. But by trying to use this as a marketing tool, I have a feeling that in many cases, those who proclaim that they're business associates and they say, "Oh yeah, we'll sign that absolutely," as you said, as an effort to get more business. This is a case of I don't think that they're thinking it through carefully either, because both parties have to realize that there's risk with this, and it may be something that they haven't looked at carefully enough. Because if something goes wrong, everybody's in the soup.
And to your point, and to this point in general, I love this quote. And Chris, in fact, the three of us talked about this just before this call. Chris, you and I have had a number of conversations about this, but it seems like common logic to say, well, when in doubt, get a BAA from your vendors just to cover yourself and make sure you're not going to have any trouble. So this quote here, make everyone we deal with sign a BAA. That way, we've covered our bases. So this would be the reverse now. of the business associates who are using BAAs as a marketing tool to get new business. Now we're talking about covered entities that are just saying, you know what, let's be safe and just put everyone on a BAA, which at face value makes a lot of sense to me. Chris, you and I have talked about this. But Ross, the reality is that's a bad idea.
I would have to say that I think that using this kind of a blanket approach really is, well, bad is a strong word. I think it's ill-advised. And the reason I say it that way instead is because on the one hand, it means that you haven't examined the business relationship you have with that party carefully enough. You see, to go to the very heart of what HIPAA is about, it's about risk management. That means that you look at what your risks are, where they come from, how they can impact you, and so on. And I have a feeling there are a lot of folks that don't realize that this contract, this business associate agreement, is not only a way of dealing with risk, but it is a source of risk as well, especially if you haven't carefully examined the situation. Because contracts are always two-way. Each party has responsibilities and accountabilities to the other. And if you simply do this, having everybody sign one, that's like asking the guys who do the groundskeeping to sign a BAA because, well, they're doing business with us, so might as well get them to do one. What would that really mean?
I think it's interesting to note that every business associate agreement is a contract, a binding, two-way contract, as Ross points out. But not every contract needs to be a BAA. And my temptation as well, and as you said, we've discussed this before. My temptation is, well, gosh, when in doubt, right? But I think Ross makes an excellent point that under the omnibus rule, a BAA really imposes some pretty significant potential penalties and exposes a business with which you are doing business to an awful lot of liability. I mean, we're talking about potentially $50,000 plus per violation of these rules. If there's gross neglect, much lower penalties if people have been trying their best essentially. But there's a lot of liability that gets exposed here, and you don't need to expose all of the people with whom you do business to that liability. Fortunately, there's some pretty good decision trees that the Health and Human Services has provided around this, but it makes the case that no matter how small a practice you are, no matter how you deal with your data, that you need to have an expert, whether it's a trainer or a consultant, a lawyer who specializes in this. You need to have someone available to really help you go through those business relationships that you have and establish where these BAAs are absolutely necessary.
Okay, so appreciate that, you guys. That one I really struggle with, even as hearing you, how much sense it makes. I guess I'm one of those people that would be guilty of making this type of statement, especially for the smaller businesses. But to both of your point, everybody who's listening to this call, you need to be extremely careful with these so that, as Ross says, you don't take on burden that doesn't belong to your organization. So be careful with that. Okay, before we turn it over to Ross and really look at what needs to go into, or rather the elements of a meaningful BAA, how to protect yourself, here are some other additional considerations that you probably are already aware of. But you do need those notices of privacy practices that go out to your constituents, your patients, whatever they may be. And it is a good idea, as both of our speakers today have pointed out, to take the care to explain to what are really your customers, your patients, that there are new rules and that they do need to read it and they do need to understand what it means because you have electronic medical records or whatever the case may be. So don't just put it in front of them with the stack, but rather take steps to make sure that they understand what their rights and responsibilities are. And also these breach notification requirements, it is something that you need to be very conscious of, because if something does happen, and let's say a business associate has a breach, some sort of unintended electronic breach of data, if you will, that you may not otherwise know about, it's very important that not only there's a policy in place to deal with those breaches, but on this last point, that you're able to enforce those policies and that your business associates know what the consequences are, with not notifying you, or what your expectation is that they should notify you. So these are other documents that should all be a part of the business associate agreement process. But on that BAA specifically now, as I said, we have Ross Leo on from HIPAAtraining.net. Ross is a HIPAA compliance instructor. So he teaches covered entities, and Ross, I imagine business associates as well, not just covered entities. I imagine you cover both, but it is your job to essentially tell people what they need to do. And when we're looking at the elements of a meaningful BAA, there are 4 main points here. And the first one you have is regulatory requirements of the business associate and its subcontractors, which we talked about. Can you give us a little more detail on that and the remaining 3 steps in how you look at this process?
Yes. First off, one of the things that begets all of this is, under the original law, before HITECH and before Omnibus, it placed almost the entire responsibility on the covered entity to manage all of the privacy. Whatever was sent downwards to business associates, the law expected the covered entity to manage everything. And it was through the vehicle of the business associate contract, as it was then configured, that the covered entity was supposed to do that. Well, what HITECH and Omnibus have done is they have taken that responsibility and they have put it into the actual body of the law. So now everybody who has legitimate access to this information is now held accountable by the law directly, as well as to the business associate contract, for how they do that, what they do, what they mishandle, or whatever the situation is. It also brought into the picture the subcontractors to business associates as part of this picture. Now here's where it gets a little bit hairy. Covered entities and business associates have a direct relationship, and it's defined by the business associate contract, another name for the BAA. The business associates also have subcontractors. But when I say it gets a little hairy, it's because the relationship of the covered entity to the business associate is not, in the same sense, extended all the way down to the subcontractors directly to the covered entity. So the covered entity is still trying to manage these relationships, but this time it's through the business associate. So here's, like I say, this is why it's a little hairy. So what we really have to emphasize at this point is the covered entity and its legal counsel needs to be very clear in the business associate contract what is required, what is expected, how things are going to manage, because the covered entity is really more or less, in a sense, the senior partner in this contract. They're still looked at by the law as being the primary custodian and protector of all this information, because they're the source of it, and they're the ones who supply it to everybody else, the business associate and their subs, if there are any. So they need to be very, very clear in the body of the business associate agreement how that's going to be done, what's going to be expected, what the penalties will be, because it has to contain sanctions as well for failures to deliver. And it needs to be complete about this, because you have to be very clear and complete in this thing, because everybody who is a party to this agreement is going to have responsibilities and legal liabilities. And a failure to be clear or complete is going to result in some murkiness. And that's a lot of the complaint that I hear these days about HIPAA. You know, it's not really clear about this, I'll hear. Well, in a case like that, you're going to have to take a position and define it for yourself. And as long as you're comfortable with what the law says, and if the law doesn't say anything to the contrary, you can define it for yourself in the body of that agreement. And that is another part of being clear and complete in those relationships.
And of course, the direct follow-up to that, you really need to make sure that you have these performance measurements and metrics in place so that you know exactly whether you're compliant and whether there is a plan to ensure that you remain compliant.
That's correct. Every contract, and for a moment think of a business associate agreement as like any other contract, You have responsibilities on both sides, things that are going to be delivered, time frames in which those things are going to be done. Some contracts talk about a thing called liquidated damages. All of this is about one party delivering the service that's promised within a specific time frame at a specific level of quality to the other. And in that sense, a BAA is very much the same. The law spells out various kinds of time frames. It spells out various kinds of documentation that each party has to have. One of the things that this particular vehicle can do is take those time frames and that documentation, and it can enable good coordination between the parties, the covered entity and the business associate, so that instead of working at cross purposes, as can happen sometimes, they're working together. They're bound together by the contract. They should be working together. And it's in an effort to continue to protect the information. It's in an effort to continue to provide high-quality, timely health care to the patient. And working together, I think overall they can do a better job. So it's a positive way to use the agreement to bring about better coordination. Because the one thing that we want to try to do is use this as a vehicle to avoid sanctions. The fact is, sanctions many times are going to end up being assessed against more than one party. And the primary is typically going to be the covered entity. Not solely and not only, of course, not under the current rules that we have. But if we can avoid sanctions for all parties concerned, then the entire system of this is better off, and the patient is still being protected even better.
And you mentioned sanctions, and that leads us right into probably the biggest, they're equally important, but to me the one that captures my attention is the concept of controlling risk.
Well, as I mentioned a moment ago, HIPAA is really about risk management. It puts covered entities and business associates in a position to identify, define, and determine proper methods for managing and controlling the risk that they face. Now, we're talking, of course, specifically with regard to the information and the likelihood of its being compromised, how that might happen, who it might be compromised to, and so on. And the law gives each covered entity and, in turn, business associates the ability to do that for themselves, because the ultimate goal is not a prescribed set of controls, as many people would feel far more comfortable with. It gives them the ability to determine what the risks are in their unique environment. As you pointed out, no two are the same. So they can do that, and they can come up with the most cost-effective controls for their specific situation. But that, of course, means that they have an awful lot more intimacy with their own environment, which is a good thing to be, ultimately. One of the things that they find, though, is that risk is transferred in both directions. You get controls, but you also get risk going from the business associate back to the covered entity, and then down from the covered entity to the business associate, and then even onward to the subcontractors. And the contract, the business associate agreement, can be used to manage that risk better by putting in certain kinds of conditions, certain kinds of controls. And these are, of course, like all contracts, are negotiated instruments. So by putting those in place, it can be used to mitigate risk for both parties. It puts risk where it belongs, which has to, again, be agreed to by both parties. But it's a vehicle where you can manage this thing itself. There are always going to be proactive and reactive approaches to managing risk, controls you can put in place to keep it from occurring. For example, the disaster recovery plan is a reactive type of control, where if something bad happens, it gives you a plan to respond to it. And that's another form of control that can affect both parties. And by developing the coordination, as I mentioned before, between the business associate and the covered entity, there can be compatible approaches where they can work together to manage risk that affects them both. And this BAA is a vehicle that can enable that sort of thing to happen. I like to look at the BAA as a vehicle to put responsibilities and accountabilities properly where they belong, but also as a way for these two parties to manage their relationship in a coordinated, collaborative sort of a way so that everybody is better off. But they have to make the effort to get that done, and that begins with understanding of the situation.
And, of course, making sure that everybody is better off, you have to talk about accountability and liability, both holding your business associates accountable, but also ensuring that if there is a mistake made, that they're covered, that they're able to take liability and to accept and stick to your policies and ensure things like patients being informed of a breach, et cetera.
That's right. The accountability and liability questions comes from a question of what is known as agency. Now, as you've said, this is not meant to be legal advice, but this is something that people are often, they're blindsided by. And the question of agency is how much of the business associate's job is actually directed actively by the folks at the covered entity? Or how much independence does the business associate actually have? The more control, and this is where the rubber meets the road, so to speak, the more direct control and involvement a covered entity has in the activities of the business associate, the more, as the law would say, the more agency there actually is. And this is one of those very subtle areas where a covered entity actually assumes greater liability than they may realize. The idea here is if you're going to engage a business associate to do a particular job for you, use the contract to negotiate particulars about what the job is, how it's going to be done, various kinds of constraints and other parameters about that, and then let the business associate do what they're supposed to do to provide that service. But the more that you do as the covered entity, the more you do in that, the more active you are, the more direction you exercise over it, you're going to find that you actually absorb more liability and have more accountability than you may have realized. So you've got to be careful when you define roles and actions and independence levels for each party to this agreement.
And, of course, we talked about this earlier, but real quick, half of the battle, and I appreciate those 4 points, by the way. Thank you very much for that, Ross. And I want to tell everybody these slides are available. You can also contact HIPAAtraining.net. The address is right in the name. It's HIPAA-training.net. We'll provide that link in just a moment. But we've talked a little bit, Ross, about when a BAA is needed, and I think that you've sort of summed it up here nicely.
Well, it really does come down to this. If the shoe fits, and even though there are people that wonder who really qualifies, the Office of Civil Rights part of DHHS has given a definition. And as you said at the top of this seminar, if you have a contractor that handles PHI for you, then they probably qualify. And there are some that don't, like the Postal Service and others. So if the shoe fits, then you probably need to do a BAA. Certainly you should give serious consideration to it. But if it doesn't, always be wary of the fact that it does create liability and risk and obligations where probably none should exist. But and like any contract, it's not bulletproof. No matter how carefully, no matter how well you craft it, it's a vehicle like every other legal vehicle. And you're going to have to defend it. You're going to have to use it. And my advice to everybody is make it as positive and as careful and as complete as you can, but always be prepared to understand the situation very, very clearly and very carefully, because we don't want anybody having a false sense of security about is it a bulletproof shield or is because they're not. Like any other contract, they're not.
And that false sense of security is a biggie. And, of course, this is the point. And, again, I want to thank Ross Leo from HIPAAtraining.net for great information. You can find them at HIPAA-training.net. I want to bring Chris Dawson back in for the Q&A section. Chris, you still with us?
I'm here.
All right, and we also, again, have Ross on as well. If you haven't already done so, you can submit your questions by simply clicking on that Q&A button at the bottom of your screen. We're going to do our best to answer as many of these as we can in the next 10 minutes or so. If we don't answer them during today's presentation, I'll pass that information on to Chris Dawson and Ross Leo, and we'll get as many of those answered after the presentation as we can. I'll take as many of those as I can. If you have other questions or comments, you can also send an email to webinars@ziffdavis.com. And as I said, you can learn more about Ross Leo's organization, HIPAAtraining.net, at training.HIPAA.net. Appreciate that very much. Okay, guys, here we go. Fast and furious. I'll call these out, read them out loud to you, and if you can please do your best to answer them as quickly as possible so that we can answer as many as possible, that would be great. Okay, the first one comes to us from Jim, and let me see if I can get this into the slide area for all of you. Jim says, is the BAA separate from a service contractor, or can it be included as an attachment or enclosure to the contract? Now, Ross, I'm going to point this one at you because I had a similar question to Jim's question, which is, if you're not sure, could you put language in, for instance, a service level agreement that says you need to let us know if at any point you intentionally or inadvertently access PHI so that we can ensure that we have the right agreements in place, et cetera. How do you cover yourself, or do you have to have a BAA in all instances if the rule applies to that particular associate?
This is actually an issue that I dealt with a few years ago. I had a very complicated situation. And what we discovered, and I talked this over with my client's corporate counsel, what we did was we built two documents. One was the service agreement, and the other was a business associate. We turned out to call it a business associate annex or addendum. The business associate addendum had everything that a BA should have in it regarding the HIPAA subject specifically, and it was an attachment in all applicable cases to a services contract. It simplifies a couple of things. For one, you don't overly complicate or clutter your business agreement about the services, but it also makes sure that the HIPAA part is covered. And since the BAA is required by the law to be reviewed for modification on an annual basis, it makes that process much simpler. But you can absolutely have the BAA done as an attachment to a license agreement or a service agreement of any kind.
And appreciate that. Go ahead, Chris.
An important clarification, though, is that it can be an addendum, but it shouldn't be sort of embedded within the service agreement. Those two things should stand alone. Even if they get combined into ultimately a sort of single document, it needs to be an addendum or an appendix such that it does stand alone.
Yes, absolutely.
And that's in direct response to Jim's question. So, Jim, yes, it needs to be an attachment or a separate enclosure, as Chris says, and Ross as well, perhaps an exhibit. Jenna wants to know, and I think we can handle this one real quickly. Ross, just to clarify, is it training-HIPAA.net or HIPAA-training.net, as I've said?
It's HIPAA-training.net.
Okay, so Jenna, thank you for that, and I see that I have it correct on the screen here, so you're all good to go. Now, John says, and Chris, this is a great one for you. Start with you on this one. Ross, feel free to answer as well. John says, what are the requirements of cloud-based suppliers that may handle something like voicemail or recording when it comes to HIPAA? Now, I feel like this one's pretty straightforward, but Chris, I guess it really depends on whether they're handling PHI data.
But if a patient could leave information on a voicemail, for example, and you could then need to say get tech support and say, hey, I can't access this voicemail. Something's gone wrong with the system, or we're trying to get transcriptions of these voicemails, for example. The chances of that provider seeing or accessing PHI is relatively high. In which case, yes, you would certainly need to have a BAA. If there's some sort of something strictly self-service, cloud-based, and you don't ever see a possibility of them accessing information, then you could probably try and apply the conduit exception. But and Ross, I'd love to hear your perspective on this. But I think this definitely would be a case in which a BAA would be appropriate.
Well, to kind of add to what Chris has already said, you have to remember, PHI can come in the form of something written, something electronic, or something spoken. So voicemail absolutely would be covered. We really should consider all of those as information, period, so that the BAA will call all three out as individual elements, but you have to treat each one as sensitive in the form that it comes to you. So I'd have to absolutely agree with Chris. We need to have consideration given, and in those cases where it seems reasonable, we've got to have a BAA for that.
Next question comes to us, and thank you both very much, and thank you also to John for that question. Next question comes from Devidas, who says, from a software vendor's point of view, for instance, somebody uses Amazon Web Service or Microsoft Azure, AWS and Microsoft are willing to sign BAAs. Does this cover the vendors that offer cloud services to their customers using AWS and Azure? So, Ross, I don't know, is that a subcontractor situation? In other words, I'm a software provider. Let's say I provide EMR service to health groups, but I'm actually hosting those records on an Amazon server or an Azure server. If Microsoft and Amazon give me a BAA and I can give that to the covered entity, am I covered, or do I also have to have a BAA under the subcontractor rule?
No, the way that I understand this to work is that if you are getting your service directly from some third party, let's call it, cloud voicemail, just for the sake of discussion. So if they are your primary service provider, your contract is with them. If they know that they're going to handle PHI, which they would through your contract with them, they then need to get the subcontract with whoever their back end is, be it Microsoft Azure or Amazon Web Services. Because as the covered entity, the flow-through is from you to your contractor, your business associate, and then from them to the sub. But it's the sub and the business associate that have the direct relationship through the contract. The covered entity manages this through their contract with their business associate. But having done it that way, and this is my understanding of the law, the covered entity does not need to have a subcontract with, in this case, Amazon, because their relationship is managed through the contract that they have with Cloud Voicemail as their actual service provider.
Great answer. Really appreciate that. Next one comes from Michael. Let's see here. Michael, thanks for bearing with us. Michael says, is there a defined process for review and response to BAA requests that you receive that identifies whether to sign, how to process, retention periods, etc.? I guess this is where you bring a consultant in, right, Ross? Is somebody that can actually look at your documentation, determine whether you're covered. Legal counsel should also be able to do this sort of thing. Are there places where these folks can go to sort of vet how they're managing their BAAs themselves?
You can. I strongly urge that this be done through, if you have an attorney, I strongly recommend that you have that. An attorney coupled with a HIPAA consultant who is an expert in that. That kind of a pairing would do everything that you need to get that contract looked at and defined. But that's really the process. It's got to be your legal authority, and it should be someone very, very familiar with the HIPAA process and the various pieces of that.
Now, Jody, Tina, John, we're going to take your questions via email. Last question of the day is coming to us from Bill, and Bill says, is there any group that reassesses an organization, either a provider, a product owner, etc., on a regular basis? I'm familiar with the Department of Defense and facility clearances. There's a government organization called DSS that comes around and checks out the company and recertifies annually, etc. So is there somebody who is actually looking at whether businesses are compliant with these omnibus rules and any other HIPAA rules, my best guess is that maybe perhaps this Department of Commerce, or is there another entity that is actually taking a closer look at these BAAs and whether businesses are being compliant?
Let me go ahead and jump in, and certainly I want Chris's opinion on this too. As far as I know, there is no agency, no government organization, no private organization that does this. I'm familiar with the DSS organization that he mentions, and they do that with Department of Defense facilities, as he says, but there is no equivalent to that in the commercial market for this. It is what you could call by exception, by event. And there are the proactive audits that were done in 2012 by DHHS on 115 covered entities. This is a situation where the government is basically, at least at this early stage, they are willing to take your word for it. If you say that you're doing this, that until they get evidence that you're not, meaning that something has gone wrong, they're going to take your word for it. But they're going to whack you really hard if they ever come looking and they find out that you haven't been telling them the whole truth or the whole story about it and something significant is missing. Now, my own conjecture, and that's all that is I suspect that some part of this will end up being under joint commission eventually. Now, I haven't heard anything to that extent or to indicate that seems to be the case. So that is purely my opinion, but it seems a logical melding of what Joint Commission is already doing for hospitals. However, as I say, there is no external entity that I'm aware of that is doing this, but you are expected to do it for yourself on an annual basis to provide evidence that you're staying compliant.
Yeah, this is very much the honor system at this point, but even if it is the honor system, the consequences of negligence particularly the omnibus rules outline monetary consequences for negligence really are significant. So one, this is a kind of blue ocean market for someone who wants to become an independent auditor, and two, I would say that this is just because they will take your word for it. Word to the wise, this is a big deal, and get an attorney, get a consultant, and make sure that you're doing this right.
Well, thank you, and thank you to Bill for that question. Everybody else who submitted questions and comments, we certainly appreciate it. Unfortunately, that's all we have time for today. I've been talking to Chris Dawson, Senior Technology Analyst here at Ziff Davis, and Ross Leo, Compliance Instructor at training-HIPAA.net. You see this address right there on your screen. Again, just a quick reminder for all of you, the information provided in this presentation does not constitute and is not substitute for legal or other professional advice, and we strongly encourage you to consult your own legal or other professional advisors for individualized guidance regarding the application of the law to your particular situation and in connection with any compliance-related concerns. I'm Josh Gingold. On behalf of Chris Dawson, Ross Leo, and myself, thanks for joining us. This has been a special presentation of Ziff Davis, ensuring HIPAA compliance with the Business Associate Agreement, brought to you by eFax Corporate, the world's #1 online fax brand. Thanks for joining us, and have a great day.